Hi, welcome to Property Law 101. My name is Sarah Bronin, and I created this course to help you understand the basics of property law. We cover 4 big questions in this series, and today we are on the 4th, which is holding interest in property. Every lawyer must learn about the estates and land. In other videos, we've covered the fee simple, the life estate, and the defeasible fees. In the case of the latter, 2 types of estates and land, there are future interests that are created in either the grantor or a third party. Some of these future interests may be subject to reformation by courts if they run afoul of a somewhat obscure rule called the rule against perpetuities. Before we break down this rule, I think I should mention for you that a 1961 California case, Lucas versus Ham, ruled that there was no malpractice in lawyers violating the rule because no one understands it. Hopefully, however, this video will give you a sense of what the rule is and why it's important to keep in mind when you are drafting grants of land involving estates for clients. So what is the rule? So the rule is no interest is good unless it must vest, if at all, not later than 21 years after some life in being at the creation of the interest. It is a rule against the remote vesting of interests. This is not a rule against the remote taking of possession of an interest, but rather the remote vesting of a future interest which is not possessory. The purpose of this rule, so why do we have it? It's to avoid restraints on alienation, avoid restraints on transferability of land, and to eliminate the influence of the dead hand. It came about to stop parties from controlling how land was disposed of too far into the future. The rule has also been helpful in establishing clear title, something that we discuss in other videos. Of course, a clear title system with clearly establishable property interests is very important. So the rule against perpetuities applies in the case of 3 types of future interests: contingent remainders, remainders that are vested but subject to open, and executory interests. The rule does not apply to fee simple absolutes or other present interests. It also doesn't apply to future interests retained by the grantor, such as a reversion, which happens after the life estate, or the possibility of reverter, or the right of entry. This is because future interests retained by the grantor are vested upon their creation. The rule also does not apply to vested remainders or remainders subject to complete divestment. And finally, it does not apply when everyone given an interest, so present and future estate holders, happens to be a charity. So back again to the rule, no interest is good unless it must vest, if at all, not later than 21 years after some life in being at the creation of the interest. So an interest, as defined in the rule, are those future interests that we've identified as being subject to the rule. Vesting, as defined in the rule, is really a state of finality when it comes to an interest. So take a contingent remainder. An interest can be contingent for 2 reasons, either because there's some condition precedent that has to be satisfied to vest in the owner of an interest, and or because the holder is not a specific or ascertained person, or because it's perhaps somebody that we don't necessarily know yet. Vesting of a contingent remainder occurs when either the condition precedent occurs and or whether the identity of the taker is ascertained. So that's contingent remainders. For remainders subject to open, so examples of that being a grant to a class of children, grandchildren, or a class of students. Vesting occurs when the class closes. For an executory interest, vesting occurs when the condition of the prior estate has been cut short. So let's move from vesting to the phrase not later than 21 years. Why 21 years? Well, really simple, because 21 years appears to be sufficient for most minors to achieve competency. Finally, and most importantly, the phrase after some life in being. The rule says we cannot create future interests unless they are somehow tied to a life in being, a life that exists when the interest is or will be created. This life is called a measuring life. The measuring life doesn't need to be the holder of a previous estate. It doesn't have to be anybody connected with the property at all. When writing out a grant of property, you don't have to explicitly identify a measuring life. But a later court has to be able to identify someone to be a measuring life to ensure that the grant does not violate the rule. So this rule is complicated. There are volumes of case law and writings about it, but fortunately for practicing attorneys, more and more states are beginning to rethink or even abolish the rule. There is a uniform statutory rule against perpetuities. It's been adopted in about half of the states, and it tries to streamline the application of the rule. Even states that retain the rule against perpetuities have adopted what they call wait and see periods to see whether, in fact, a future interest actually does vest within a specific period, even if the terms of the grant might otherwise be invalidated by the rule. So you also see cases of courts modifying grants of property so they don't conflict with the rule. An example of a reform is reforming a provision that says that somebody has to wait for 25 years to make that 21 years. Another example is severing the part of a class that violates the rule against perpetuities. So as much as I would love to continue to delve into the details of the rule against perpetuities, I'm going to leave the conversation here. I would love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list. See you next time.